Mr. Danian, I have read your objection. Um, Anything else you'd like to say?
Thank you very much, Your Honor. I realize that the timing on this, the child has already started school in Newaygo County. My client timely objected, but we could not get in any earlier for a hearing date. It's not her intention to cause further disruption at all, to this minor child. I realize that it's probably not going to be wise to now take the child from Newaygo County, bring her back to Kent County, and we have a hearing scheduled for next week, I think on the 8th, with regard to the motion for a change in domicile. But she had.
Right away, this case centers around something courts treat very seriously: school stability. Judges often prioritize keeping a child in the same school once the year has started because sudden relocation can disrupt emotional development, friendships, and academic performance. But there's another tension building here. The mother claims she hasn't seen her child in 2 months. So now the court is balancing stability versus parental access. And that's where cases like this get complicated fast.
Voiced your objection, and long term we do want the child in a stable school environment. I think another issue that my client wanted me to address with you today is that she's not had any parenting time at all now for about 2 months with this minor child, and we're trying to see if something like that can happen immediately, even though the hearing's scheduled for like I said, I think September 8th is the hearing. The ex parte order, my client, before she retained me, indicated that she had never even gotten served with that ex parte order, or she would have objected immediately. So we're in just a predicament here because of the nature of these hearings and kind of where we're at. But she's gotten no, I think, response from the defendant. He has extended parenting time, as you're well aware. But we're trying to do something here, even in the interim, so my client can see the minor child. If we could address that today, I think that actually takes predominance over the school issue until we have our hearing next week.
Okay, Mr. Shepard?
Yeah, thanks, thanks, Judge. As the court will recall from this case, my client's concern is essentially that this well, I want to say this correctly, Judge. If I look at this and I say Miss Montoya, when I say vanished, that's exactly what happened.
Now we're hearing allegations of parental disappearance and evading service. And in family law, that can seriously damage credibility. If a parent is seen as unreliable or potentially planning to relocate again, judges often lean toward tighter custody controls. But here's the big question for viewers. Is this about protecting the child, or is it a custody strategy? That's exactly what the judge will have to weigh.
Courts read our pleadings. The problem is that my client has been very uncomfortable with allowing Miss Montoya to be anywhere near this young lady because he fears that she was going to leave, not be in the state. She doesn't know where she's residing now. She had unilaterally made the decision to go to North Carolina, unenrolled this child from Godwin Heights, and my client played heck, even finding her, hiring a process server down in North Carolina, which Miss Montoya effectively evaded. And so if we're looking at this from a position where should Sophia continue, she is in school, she's fine, everything is going great, it's stable now. And so that should continue. I agree. What may come with these proceedings and hearings with regard to the motion to change domicile, obviously the court will address that. If the request is for some parenting time, Judge, I don't know that my client will object to that, but it needs to be controlled, and it needs to be here in Kent County, and it needs to be all of those things. As I indicated on my filings, my client's position is that Ms. Montoya was very evasive and very non-committal about where she was or what the plan was. And so that's why he has been super hesitant, because again, he took the spring and the summer of this year to even find his daughter and get her back. And he did not want to do that again, not knowing not trusting Miss Montoya. And so that's kind of where we're at, Judge. And so we'll leave that in the court's discretion. She's in school, she's stable. My client is able to get her back and forth there. And so I appreciate the idea.
This is a major turning point. The judge orders supervised parenting time. That's not punishment. It's a safety precaution. Courts typically use supervision when there are allegations of instability, relocation risk, or safety concerns. It allows the parent-child relationship to continue while reducing the risk of potential custody violations.
That we shouldn't disturb this. As it relates to parenting time, Judge, you're the boss. We'll do what you say, but understand my client's concerns given what he and this 6-year-old have been through to even get to this point.
All right. Well, I think given all the issues here, at least the allegations, that number one, parenting time needs to happen if this child has not seen her mother for a couple of months. And secondly, due to the concerns, at least the allegations that I'm hearing, I think it should be supervised. And I will leave it to the attorneys. I don't know if you want to go back in the waiting room and the two of you see if you can work something out regarding a schedule and then come back on the record, or what you would like to do. I don't necessarily want to hash this all out in open court, but those are kind of my parameters. Is that parenting time should happen as soon as possible, and that it should be supervised or in some environment where the defendant can feel comfortable that Ms. Montoya is not going to take the child and leave.
Understood, Your Honor. Happy to have that conversation. Mr. Danny and I have multiple cases together, and I believe we work well together, and I believe we can take the lead from the court, take the direction in that regard.
All right, so we'll put you back in the waiting room, and then if you would just let Ms. Gibson know when you're ready to come back and either talk to me or go on the record, or if it's been resolved, that's fine too. Just let us know.
Is it possible to do breakout rooms, or if we go back in the waiting room, it would require calling each other?
Well, there's a chat function, but
okay.
we can do a breakout room for you as long as you promise not to leave the breakout room, because what'll happen is you'll pop into the middle of another hearing that I have going on. So as long as you stay in the breakout room, I have no problem with that and then there's a chat function. You can let us know that you're ready.
Say, hey, we're ready. Okay.
But it may be a few minutes if we're in the middle of another hearing.
Understood, Your Honor.
Okay. And you want all four of you in the breakout room, or you just want two attorneys?
I think the two attorneys would be more appropriate.
Okay, I think so too. I'll put the parties back, or we'll put the parties back in the waiting room, and Ms. Gibson will create a breakout room for you and Mr. Danian.
Thank you, Your Honor.
Okay, the breakout room is open.
They would like to call the mother here in this matter. Ma'am, can I get you to state your name for the record?
Salamite Galai.
And the name of the child or children that we're here in reference to?
Isaac Kuroki.
And the name of the child's father?
Joseph Kuroki.
And did you hear what I previously read into the record as it relates to this case?
Yes, I did hear.
And are you in agreement with those terms only that were provided to the court?
I'm in agreement with those terms, yes.
All right. And are you requesting that the court accepts those agreements and make them the order of the court today?
Yes.
All right. Now, moving forward to the contested issues. Has there been any issues relating to family violence between you and the other party to this case?
Yes, there has been.
Has there been anything within the last 2 years?
Yes.
And when was the last incident, ma'am?
About 8 months ago. Yeah.
And what happened during that incident?
He showed up to my home after we separated about a year and a half ago. So he showed up to my home around 11 o'clock unannounced, just very kind of volatile. My friend was here as well. He pushed me, trying to get access to his son, which my son was sleeping. I guess that's the reason, but pushed me, kind of shoved my friend. I called the police a couple of times. They didn't show up that night. And then the next morning he came back and I didn't allow him in my home. I called the police again. They showed back up. 3 officers took my statement. And then after that, we try to keep our discussions and things to like a minimum, but there's been issues with our relationship.
And other than this incident that you spoke of that took place about 8 or 9 months ago, has there been any prior incidents?
Another crucial layer enters the case. The child has autism and requires therapy and specialized care. In custody disputes, courts often give significant weight to which parent manages medical appointments, therapy schedules, and educational services. Consistency in special needs care can heavily influence who receives primary custody.
We've had quite a few incidents. I didn't always call the police or, make a record of it, but we've had a pretty toxic relationship.
All right. But just to confirm, you did call the police in reference to this last incident, correct?
Yes.
And based off of that incident and the prior incidents that you spoke of, are you still okay with you and the other party being named as joint managing conservators, or are you requesting that you be named as the sole managing conservator?
No, we can both. Joint is fine. He's never been harmful to his child or anything like that. And he loves his child, but so joint is fine.
Do you feel that you and the other party could come together to make decisions together that are in the child's best interest?
Yes, I think we can.
And have you two been able to do that in the past?
Somewhat. I mean, it's a hard relationship, but we have sometimes we disagree, but my son is I would say 90% of the time with me. So I do most of the schooling. My son is autistic. So as far as like transport to and from therapy and ABA and speech and everything like that, I've been doing that, but we do come to a decision based on like what school and things like that.
All right. And as it relates to the insurance, how does the child currently receive insurance?
So he's currently on Medicaid. He's been on Medicaid for only about a month, I would say. Joseph lost his job in February. So my son lost his insurance, so we had to apply. He was without insurance for about a month or two, and then so we applied for Medicaid. At that time, he was unemployed, so we did receive the Medicaid. We finally got the the funding, but now Joseph is working, so I fear that the Medicaid will probably drop my son. So I think we're trying to put him back on Joseph's insurance.
All right. Thank you, ma'am. And as it relates to the child support, just to confirm, you are requesting that the father pays child support in the amount of $1,158 based off his income. Is that correct?
Yes.
And are you requesting retroactive support from May 2024 to present date?
Yes.
Just one moment.
But I am willing to negotiate. I do want to say that, like, if the number is a very large number, and I know, I'm not in it for like the money. So I am willing to negotiate if he's okay with that.
All right, just one moment, please. All right, the state has used the reported income for the non-custodial parent for the calculation of retroactive support and requesting to take a retroactive support judgment in the amount of $18,361.50 to be paid at $142 per month. Are you in agreement to that amount?
Yes, sir.
And since the two of you separated, the child has primarily been residing with you. Is that correct?
Yes.
Has the father been providing you with support for the child financially?
He's given me $1,000. I would say since May, but he did give me $1,000.
All right. And with the credit for $1,000, the state would request to readjust the retroactive support judgment to the amount of $17,361.50 to be paid at $130 per month. Would you be in agreement to that amount?
Yes, sir.
All right, thank you, ma'am. And as it relates to visitation, has the father had any visitation here recently with the child?
Yeah. About a week ago. When was it? He has, but it's not over the past since May of 2024. He's probably seen him 20-25 times, like keeping him at his home. He likes to FaceTime. I do most of everything. Me and my family, my friends.
Thank you, ma'am. And would you be in agreement to the father having a standard possession order as it relates to visitation going forward?
Yes.
And are you in agreement for the father to pay the court costs associated with today's hearing?
Yes.
Do you have any additional information that you would like to offer to the court today?
No, I think that covers it.
All right. Nothing further from this party owner. At this time, Your Honor, the state would like to call the father in this matter. Sir, can I get you to state your name for the record?
Joseph Kuroki.
Mr. Kuroki, did you hear what I previously read into the record that was agreed to by the parties?
I did.
And only in reference to those terms that you previously agreed to that were provided to the court, sir, are you still currently in agreement with those terms only?
Yes, those times only.
All right, thank you, sir. And are you requesting that the court accepts those agreements and make them part of the order today?
Yes.
Thank you, sir. As it relates to the issue of family violence, did you hear the mother testify that there had been some issues relating to family violence within the past 8 to 9 months?
Yes, I had some very serious but false allegations.
All right. And, sir, has there been any family violence between the two parties within the past 2 years?
Yes, as a matter of fact, I intend to present a video showing the incident in question. I have it right here for presentation report.
And when was the last incident, sir?
Looking at the dates, give me a second. I will tell you exactly what date that was. That was June 29, 2022.
Did you say 22, sir? June 29th, 2022?
Yes, and then there have been multiple. There was one year and a half where she claimed that I touched her. Police were called. They investigated. No charges were filed because
And was that
there was no domestic violence, or no family violence.
right? And was that the incident that took place about 8 or 9 months ago?
Yes.
All right. And just confirm it stated that the police were called and an investigation was conducted, but they did not have any charges pressed against you. Is that correct?
Yes, because there was no proof. There was an allegation made. There was no proof. I am a military veteran, Marine Corps veteran. I have a security clearance. I've never had any violence in my record at all. So I completely deny that allegation.
All right. Thank you, sir. And sir, are you currently employed?
I am. I have started my new job June 2nd. There was a break of unemployment this year from February to June. But I am currently employed, yes.
And are you requesting that you carry the insurance for the child going forward?
Absolutely. I've been my son's primary caregiver for 5 to 6 years of his life. I've always provided medical insurance. My insurance is typically very comprehensive. I choose to pick that.
Now, the conflict shifts toward finances, specifically child support. What makes this tense is that the father isn't denying responsibility. He's arguing involvement. And legally, active parenting time can sometimes influence support calculations, but it usually doesn't eliminate them. Courts calculate support based largely on where the child primarily lives and each parent's income.
Highest insurance so I can cover my son's needs 100%. Currently, my insurance is $1,200 a month. I have added my son to that insurance, and I intend to keep him on that insurance. Medicaid, it's against the law for me to have him on Medicaid and private insurance. I am the one who actually got him on Medicaid. I've always led his medical treatment.
All right. Thank you, sir. Just one moment. And you spoke about the $1,200 amount for the insurance. Is that $1,200 encompass both you and the child, or is that just for the child to be covered?
That is for me and my son. That is the plan that allows him to have the best benefits. It's all about him. It's not about me. So,
and what is the child's portion for the insurance?
If I was going to go on it myself, it's very cheap. It's like $50 something every couple of weeks. I'm a healthy adult male, and I don't need that insurance. But the Blue Cross, Blue Shield, platinum level insurance through my company costs me $600 every 2 weeks.
Yes, sir. As it relates to child support, the state is requesting, sir, that you pay child support in the amount of $1,158. Are you in agreement to this amount, sir?
No, and I do have to just get.
Sir,
Yes,
explain to the court. Could you give me just a moment while I state the question, sir? Could you explain to the court why you don't agree to paying the child support based off of your income?
Well, not based out of my income. But quite frankly, on it would be very easy for me to just write a check and just move on with my life. But the reason I'm denying this is very comprehensive. One, contrary to what the other party has said, I am a very active parent to our son. I have been his primary caretaker 5 years out of the 6 years he's been alive. I see as a matter of fact, the last time I saw my son was Monday, when she dropped off our son to my house. So I'm a present father. I'm an active father. I dress my son. I actually have lunch with my son every day at his therapy, every day without fail. And that is something that can be attested by his therapist. I'm disputing that amount because I'm a present father, 100%. I have said that we have an exchange pretty much every day. She's refused that. I said I can pick him up after my job, drop him off in the morning.
Thank you, Mr. Joseph. Okay. And as it relates to the retroactive support, the mother's requesting retroactive support for the past 13 months, giving a credit of $1,000. The state will request to take a judgment in the amount of $17,361.50 to be paid at $130 per month. Are you in agreement to that amount, sir?
No, I'm not. The reason I'm not in agreement with that is...
Mr. Carriot, sir, thank you. And as it relates to the amount, sir.
It's karaoke.
Okay, thank you.
Okay.
As it relates to the amount, sir, how much money would you provide that you've given to the mother over the past 13 months?
So I have given her $1,000 because I was unemployed between February and May. But other than that, my son's been staying with me and her. It's been a very joint 50-50 custodial agreement up until really December of this year. And she knows exactly what happened. And that's why we haven't had a good relationship since December. But since May, he was at my house when she worked. When I was working, she was with him, but I would put him to bed every single evening. So it's not like our son has been just with her this whole time. And that's really why I'm disputing this.
All right. And sir, you stated that the mother knows why the situation changed as it relates to the child sometime in December. Is that in reference to the incident that she spoke of relating to possible family violence?
I'm glad you asked that. So no, it's not that. The mother, let me finish. You asked me a question, let me finish.
All right, you answered the question, sir. Thank you.
I have not answered the question, Your Honor. I'd like to answer the question. The reason this changed is because I found out that the mother was having sexual relations with her drug dealer. And I found the drug dealer sneaking out the back door. So she was having sexual relations with both of us. That's part of my concerns about her behavior and fitness to be a parent.
All right, thank you, sir. As it relates to the visitation, when was the last time you had visitation with the child?
This Monday. She dropped him off in the evening. I walked my son, played with him, dropped him off at her house. I'm very consistent when it comes to time with our son.
Thank you, sir. And prior to that,
I have the text messages to prove that as well.
Sir, as it relates to the visitation, prior to that Monday, when was the last time you had visitation with the child? Prior to that,
it was last week, Thursday.
And was that an overnight visit?
Overnight. It's always overnight.
And what time did you get the child, and what time did you return the child?
So she dropped him off in the evening, dropped him off at a place in the morning.
So again, sorry, what time did you get the child?
In
On
the evening,
Thursday?
at 6:30 p.m.
All right. And when did you return the child to the mother?
by 8 o'clock Friday morning.
All right. Thank you, sir. Now, as it relates to the exchange of the child, the mother is requesting that the exchange take place at the Bath and Body Works located at 5331 East Mockingbird Lane in Dallas, Texas. Are you in agreement to the exchange to take place at that location, sir?
No, there's no basis for that location other than it's like 5 minutes from my house. So she would essentially be skipping all the traffic to my house. We've been exchanging our son at our homes. So she wants to change it now. If she wants a precise 50, halfway location, we've actually done a calculation. We've actually exchanged our son, several times, and that is the shops at Highland Park. So I don't mind us exchanging our son somewhere away from our homes, even though we did it as soon as this Monday. But if it's a 50-50 location where we're sharing the burden of exchanging our son, then let's keep it where we've been exchanging him, which is at the shops at Highland Park. It's literally halfway between our homes.
All right, thank you, sir. And as it relates to the court costs, you don't agree to paying the court costs associated with today's hearing, correct?
Well, I don't agree because there's so much as far as the level of involvement I have with my son, the cost that I put in on my son, his care. I feel that any court costs should be split between two.
And here comes the judge's final legal analysis. Notice how the court separates relationship conflict from actual family violence. Arguments, toxic communication, and distrust may damage co-parenting. But without proof of physical harm, courts often avoid labeling it as domestic violence. That distinction dramatically affects custody rulings and visitation rights.
Nothing further from this party, Your Honor. Your Honor, if I could quickly recall the mother just to address the allegations of a prior 50-50 split.
Okay.
All right, thank you, Your Honor. Ma'am, can I'm sorry, I thought you were on mute. As it relates to the child, ma'am, has the father and you been splitting the child 50-50 as it relates to where the child would reside?
Absolutely not.
Has the father had multiple days to which he had the child at a certain period of time?
Like I said, probably since, a year and a half ago, he's probably seen him, had him. The most he's had him was for like 2 days in a row. It's never, and during his work hours, he won't pick him up from school. There's so many things that he will not do. He's unwilling to do.
And do you know the father's work schedule?
He works from home, I guess, Monday through Friday, I guess 8 to 5, something, business hours. And then he used to travel. I don't know where he works currently with his, before he lost his job in February, he would travel for business as well.
And you stated that the longest he's ever had the child was for 2 days that you could remember. Is that correct?
Yes, sir. Consecutively, yes.
Okay. All right. Do you have any additional information that you could you would like to offer to the court relating to the possibility of the 50-50 split?
No, I don't think so.
All right. Nothing further from this party.
Thank you.
All right, let me go ahead and make all the findings. Okay, so first, of course, we're establishing that Mr. Kuroki is the biological father. As far as the family violence, I didn't hear anything of there was physical violence. It sounds like y'all didn't get along very well. You've had arguments. Maybe, the showing up at the wrong time. That's maybe an issue, but I haven't heard any evidence or seen any evidence that there's been physical violence. So other than y'all just not getting along with each other, I don't consider that to the rise of the level of me making a finding of family violence. So I'm not making a finding of family violence ruling. I'm appointing y'all as joint managing conservators. Child support for the future has to be paid. The child primarily lives with mother. It's not a 50-50. I think that's pretty clear. So you have to pay child support, Mr. Kuroki. I mean, even though you don't like it, you're gonna have to pay child support based on your wages. Your child support is $1,158, and that's for the future. That's not based on anything in the past. That's based on that the child's going to reign primarily with the mother, and you're going to be visiting on the weekends or whenever you have available time. But primarily, the child is at least 75% with mother, and you have to pay child support. The health insurance, I don't know if you can find anything cheaper, but usually the mother or the person that has the child primarily will be the one to apply for Medicaid. If the child has some special needs, it's possible that you might be able to get Medicaid based on the special needs. But that's something y'all can look at and see if that's something you could do. I mean, obviously, it's also based on income, so it may or may not work. I don't know, but something to look into in the future. Sometimes when we have disabled children, if that's the case here, they may be able to give you Medicaid even though there may be an income issue. So I don't know. That's something to explore. Insurance. I'm not asking for comments, sir. I need you to listen. Very important that you listen now. Okay, so for now, Mr. Kurogi is going to be the one primarily responsible for the insurance. It is very expensive, obviously, so I understand that, but that's the only thing we have available right now. So we're having you be the primary responsibility of carrying insurance. Make sure Miss July has a copy of any of your insurance cards. If they change, make sure she gets updates about that. For visitation, we're doing standard visitation, which is the first, third, and fifth weekends of each month, from Friday at 6 until Sunday at 6. If y'all agree to something different, then that's okay with me. I'm okay with that. But if you do not have an agreement, then those are the times you get visitation, not other times. So it takes both of you to agree, not one person telling the other person what they want. Okay, so both y'all agree to something different, that's fine with me. But if you both don't agree, then you're doing the visitation schedule on the weekends. The exchange location, that sounds reasonable. I don't understand why I'm not going to make Miss July drive halfway to meet you somewhere. That doesn't make any sense. The normal order would be that you're going to meet at her residence to pick up and drop off the child. So meeting 5 minutes away from her residence isn't that big of a difference. And based on y'all having issues with drop-ins or coming to a residence when you're not supposed to, it makes sense that we would want to do an exchange location. And that way both of y'all are protected from any false allegations or actual things that may happen. If you meet in a public place, hopefully that means y'all will act better. And if you don't, then there'll be witnesses. So I think the exchange location makes sense, even though you may not like it. It makes a lot of sense to me. Retroactive judgment is $12,000 instead of the $17,000. So $12,000 is what's owed for the past, payable at $100 a month until paid in full. Court costs billed to Mr. Kuroki. All right, the Attorney General's office will draft the order based on my ruling. I'll sign off on that. They'll email you a copy. If you're self-employed, you'll need to send in your own payments to the child support office so they can record your payment and send it through the Attorney General's office, send it to the mother. It sounds like you're employed, so they'll probably just send out a withholding order just to take it out of your check every 2 weeks or however you get paid, and make sure they know about any changes in employment so there aren't any gaps in any child support payments. All right, that'll be my ruling. Y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
Thank you, Honor.
Thank you, Your Honor.